हाँ यार पहले मैं इनकी वो साइड
ठीक ठीक मुझे दे दो, मैं रख लेता हूँ अपने पास ही।
हाँ शुरू करें बिस्मिल्लाहिर्रहमानिर्रहीम I think we should start now. Are we online? Okay, thank you. I'll invite Saddam Sab to start with the Quran Khwani and then we will start immediately. Thank you.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. خلق الإنسان من صلصال كالفخار وخلق الجان من مارج من نار فبأي آلاء ربكما تكذبان رب المشرقين ورب المغربين فبأي آلاء ربكما تكذبان مرج البحرين يلتقيان بينهما برزخ لا يبغيان فبأي آلاء ربكما تكذبان فبأي آلاء ربكما تكذبان يخرج منهما اللؤلؤ والمرجان فبأي آلاء ربكما تكذبان وله الجوار المنشآت في البحر كالأعلام وله الجوار المنشآت في البحر كالأعلام فبأي آلاء ربكما تكذبان فبأي آلاء ربكما تكذبان صدق الله العلي العظيم.
Bismillahirrahmanirrahim. For those of us joining us today for the first time, अब हम अपने दूसरे मरहले पे हैं in the teaching of the bar vocational course. ये कोर्स अडेप्ट किया गया है हमने बैरिस्टर्स के कोर्स को in accordance with पाकिस्तानी legal practices and पाकिस्तानी law. इसका दूसरा मरहला स्टेज 2 आज शुरू होगा. For those of us who are not aware, stage 1 was advocacy, oral and written advocacy, ethics, and now at stage 2 we start with certain special laws और उसकी शुरुआत हम आज arbitration and alternative dispute resolution के कवानीन के थ्रू करेंगे. आज के जो लेक्चरर हैं Zahid Ebrahim साहब हैं. He is a very distinguished practitioner and he has his own law firm here in Karachi as well as in Lahore. Islamabad as well? and a branch office in Islamabad as well. His father was also a distinguished practitioner, after which he was elevated to the Honorable High Court of Sindh as a judge, and subsequently he also became a governor of Sindh, Fakhruddin G. Ibrahim Saab. For those of you who do a lot of extensive research in case law, you will come across his judgments. So Zahid Ebrahim Saab will take over today and start stage 2 of our lecture series. Thank you.
Thank you very much. First of all, I think I'd like to commend the Legal Outreach and the Sindh High Court Bar Association for coming up with this lecture series. Hopefully, this will be a good interactive session and we will all come back with some questions. I've been asked to speak on arbitration. Arbitration, we all hear about it. In fact, I would say that arbitration and ADR, alternate dispute resolution, ये वो टॉपिक है जो बहुत ही ज़्यादा पॉपुलराइज हुआ है. एंड अगर आप अपने करियर में देखेंगे, जब भी लॉ कॉन्फ्रेंसेस ऑर्गेनाइज होती हैं तो समहाउ ADR और आर्बिट्रेशन एंड मीडिएशन के ऊपर बहुत फोकस रहता है. एंड ये फोकस क्यों रहता है? Why do we have alternate dispute resolution? Because all of us who went to law school put on a black suit. I thought हमें dispute resolution के लिए ही expertise अपनी सारी पढ़ाई इसीलिए की थी कि dispute resolution में हम expert बनेंगे and we'll participate as lawyers and then move on in our careers. So why are we talking about ADR, an alternate dispute resolution, which is something which is alternate to the dispute resolution processes, methods and machinery which we are all accustomed to? What is the dispute resolution method which is available to the general public, to us as practitioners, is a court of law, right? This is where we all want to come to have our cases argued and decided as litigant to get a decision or relief from the court. But over the years, there has been a growing feeling that dispute resolution simply in the hands of courts of law is perhaps not adequate. It is not enough. हमें somehow इससे थोड़ा सा आगे बढ़ना है और specialized dispute resolution methods बनाने की ज़रूरत है, जिसके अंदर arbitration and in fact mediation are two well regarded processes. So arbitration, पहले तो ये देख लेते हैं कि ADR में ठीक है, mediation भी शामिल है, arbitration भी शामिल है. What is mediation? Mediation is a method of trying to mediate, trying to put forward a conciliation between parties and therefore coming up with a dispute resolution process which perhaps may be non-binding, but it allows parties to resolve their disputes. Generally, as lawyers, we tend to be a bit sort of apprehensive when it comes to mediation or even ADR का हम जब नाम सुनते हैं. हमारा ख्याल है कि somehow lawyers अगर मीडिएशन हो गई तो फिर वकील क्या करेगा, केस कहाँ जाएगा. बट हमें इससे थोड़ा सा आगे ये सोचने की ज़रूरत है कि मीडिएशन में भी वकीलों का एक बहुत सेंट्रल कैरेक्टर है. देयर आर नाउ lot of young lawyers who are getting themselves accredited as recognized mediators. And as we have more and more mediation happening, you will see that lawyers perhaps will take on a more effective role and a more productive role for their advancing their professionals in this sphere. My purpose today is to perhaps focus a little more on arbitration. Arbitration, if we try to even understand कि ये arbitration चीज़ क्या है, we've all read and studied it. If we try to simplify it, arbitration is effectively a private system of adjudication of commercial disputes. So we have two parties or two individuals who have a commercial dispute, and instead of going to court, they have agreed in writing that we will have a private adjudication of our dispute if there is a dispute between us. ठीक है? Now, वन जब मैं प्राइवेट एजुडिकेशन की बात करता हूँ तो उससे क्या मकसद क्या है? प्राइवेट एजुडिकेशन से मकसद ये है कि देखें, जब हम कोर्ट आते हैं तो हु इज़ द सेंट्रल फिगर इन योर लाइफ व्हेन यू कम टू कोर्ट? इट इज़ द जज, राइट? ही इज़ द वन बिफोर whom you will plead your case, put your submissions, and then hopefully get a relief. With private adjudication, what you are doing or what the parties are doing is that they have a judge of their choice. Judge of your choice. Imagine, as a lawyer, you have an opportunity that you will have a decision maker that you have agreed to, that you have appointed. Now, इसका ये मतलब नहीं है कि आपने जज ऑफ योर चॉइस से, मेरे ये मुराद नहीं है कि आप अपने दोस्त को आर्बिट्रेटर अपॉइंट कर देंगे ताकि वो एक फ़ैसला परहैप्स आपके झुकाव उसका आपकी तरफ हो. बट इसका फोकस एक्चुअली ये है प्राइवेट एजुडिकेशन से कि you will have a specialist person, a person who has expertise of that area to adjudicate and decide the dispute. Now, by specialization, what I want to perhaps explain is, for instance, when I said adjudication of commercial disputes. अब आर्बिट्रेशन में ये भी काफ़ी हो गया है कि फॉर इंस्टेंस लॉट ऑफ, आप देखेंगे अगर आप किसी इंजीनियरिंग कंपनी या कंस्ट्रक्शन के बारे में कॉन्ट्रैक्ट पढ़ते हैं तो उसमें हमेशा एक आर्बिट्रेशन का क्लॉज हमेशा होता है. अब एक इंटायर क्लास ऑफ लॉयर्स डेवलप हो चुकी है जो कंस्ट्रक्शन लॉ के स्पेशलिस्ट हैं, लॉयर्स एंड एज आर्बिट्रेटर्स. हमारे यहाँ बिलाल साहब मरूम, who was an engineer himself, was an expert in construction law. So construction law, even I would say internationally, so definitely it is a big expertise, but also nationally, domestically, there is a definite group of practitioners and adjudicators, arbitrators, who you will say that these are people who understand construction disputes. For instance, internationally, sports arbitration एक बड़ी चीज़ है. सिर्फ स्पोर्ट्स डिस्प्यूट की आर्बिट्रेशन, स्पोर्ट्स डिस्प्यूट की आर्बिट्रेशन के अंदर स्पेशलाइज करने वाले वकला. तो what has this private adjudication of disputes से हमें फ़ायदा ये होता है कि you are able or the parties are able to have a dispute decided upon by persons who you think will be an expert of that area. Now, as I hope to speak to you, if at any stage you have a question or you think that there's an experience of your own which you need to add, just please raise your hand and I will try to take those on and answer them and adapt my speaking engagement with you. So, ये तय हो गया कि arbitration is a private adjudication. A private person will be appointed as an arbitrator. Yes, there will be two parties. But understand this, in distinction to mediation, arbitration still has to be made, the decision making in an arbitration has to be made as per law. So, legal basis still is fundamental to that decision making process. मीडिएशन में आप कह सकते हैं कि वो यू इंकरेज वन पार्टी टू कॉम्प्रोमाइज, perhaps understand the realistic situation, but in arbitration you cannot decide, or the person who you appoint as arbitrator, he does not have the luxury of deciding on something other than law. So you have to have an arbitrator. An arbitrator can be a person who the parties choose, but the law has to be there. You cannot avoid the law. Yes, you do have a choice, and you see again in especially in agreements where one of the parties may be foreign, that you can even choose the law. An arbitration agreement may allow the parties to say that this agreement, or the agreement that you draft for a construction project, let's say in Hyderabad, that if there is a dispute in relation to that construction project, you can decide that that dispute in relation to that will be decided not by Pakistan law, but you can decide that that will be decided in accordance with UAE law. So arbitrations allow you to do that. Arbitrations also allow you, कि dispute is in relation to a project at Hyderabad, you have a that contract or dispute to be decided according to the laws of UAE, and you may decide that the arbitration will be conducted, let's say, in Malaysia. So imagine the choices. You are deciding a decision maker, the arbitrator of your choice. You are deciding where that arbitration is to be held, again party's choice. You are even making a choice of law, of what is the law that is going to apply to that dispute or to that arbitration. So you can have a dispute decided, let's say, by an arbitrator who is national of Hong Kong. You can have the arbitration hearing in Dubai, and you can have the law of Pakistan as the applicable law. All of this is possible in an arbitration, which is obviously, when we think about a court of law, that is certainly not even part of our thinking process, right? We know that the law is going to be the law of Pakistan. We know that if you come to the High Court, it will be a judge of the High Court, and the laws will be laws of Pakistan, which is completely different when you come to arbitration. Now, okay, if all that is possible, what are then the key elements of an arbitration process? Why should we, isn't it instead जो बात मैं आपसे कर रहा हूँ कि आर्बिट्रेटर हांगकांग का कानून, दुबई का प्रोजेक्ट हैदराबाद में, उससे फ़ायदा क्या है? What is the use? Why not just go to a domestic court and get our decisions from that local court? The decision, yes, both allow for that same definitive decision making. The difference that is of emphasis is, number one, that I identified, was that you can have the decision by a specialist of your choice. So obviously, if you are involved in a construction dispute and it is of a substantial monetary value, your interest is कि यार जो जज जिसको या वकील या इंजीनियर जिसको हम आर्बिट्रेटर अपॉइंट करें वो उस फील्ड की एक्सपर्टीज़ तो रखता हो. अगर वो एक्सपर्टीज़ होगी तो one, it will be easy for him to decide, and two, it will be easy for him to decide as per the law. So there are three elements when we look at, when we think of arbitration and we think of why generally people prefer to arbitrate. One, the first element is privacy. The arbitrations, because obviously it is not in a court of law, it is done between two parties, their lawyers and an arbitrator. It has an element of privacy to it, right? There are no publications, at least if we look at even in Pakistan, there is no publication, there is no PLD where awards are published, right? So awards, and even generally, internationally, awards are not that easily available publicly. So there is an element of privacy which often parties may choose not to make their disputes public. For instance, it's very interesting. Pakistan was involved in a major international arbitration in relation to Karke. I don't know if some of you may have heard about that. Karke was a offshore private power producing entity, and there was a dispute which eventually went to international arbitration. It was a treaty arbitration. But I just want to plug in this element of how privacy plays a role. Karke ke andar arbitration hua and it resulted in an award against the government of Pakistan of almost about $1 billion. Instead of that arbitration award being enforced, it was settled privately by the government of Pakistan with that private entity, Karke, and you ended up, right now, nobody is really even aware of what happened to that dispute, how that dispute got resolved, what were the terms of that dispute. It is not coming to any court of law. It is a dispute where the chapter has been closed between the two parties. So, the first element of arbitration as a choice is that it affords a sense of privacy, confidentiality to parties. ठीक है? जिसको आप कहते हैं कि भाई we don't want our dirty laundry to be washed in public. So here it allows disputes to be decided with a relative element of confidentiality and privacy. Now, privacy in the Pakistan experience of arbitration law perhaps also becomes complicated because we have a legal system which says that, and I'll come to this later, कि arbitration का जो decision होता है, जो judgment होती है, जिसको हम award कहते हैं, the award, in order to be enforceable, has to be made rule of court. And this is perhaps really an enigma and perhaps one of the, I won't say failures, but certainly challenges of Pakistan arbitration law practice, that when the award comes to court to be made rule of court, what happens then? And I will come to that. But First element of choosing arbitration as a dispute resolution process advantage is privacy. Second, I would say, is the efficiency of the process. That with a private adjudication process, you will get, when you go to an arbitrator, the first thing he will do is to set up a timetable on how the pleadings, by certain weeks, pleadings have to be filed, by certain weeks, issues will be framed. So you have the entire arbitration timetable set effectively on the first date. And you see this as more and more professionals get involved in arbitration, that what they do is to set up a timetable which parties can then follow and rely on. So that creates an efficiency in the process. It's not like you come to court, go to the registrar's office, से अच्छा भी हमें 30 दिन का और टाइम दे दें रिटन स्टेटमेंट फाइल करने के लिए, फिर उसके बाद आप एक और एप्लीकेशन करते हैं, आप एक और एप्लीकेशन करते हैं. With an arbitration process, it is much more regulated and disciplined in that sense. Because that arbitrator, as compared to a judge sitting in court, he does not have dozens of cases before him. He is ideally dealing with a few, and when he fixes a date before the arbitrator, he is going to hear one set of parties and one case before him. So it allows allows the arbitrator and the people involved in the process to conclude the arbitration relatively efficiently. Okay? For instance, हमारे arbitration act में लिखा हुआ है कि the arbitration should be concluded in a matter of 4 months. Yes, it does not usually get concluded in 4 months, but it's still processes of arbitration, procedures of arbitration allow parties to conclude their disputes relatively quicker. Even internationally, which are very complicated arbitrations, वो भी 1-2 maximum 3 साल में मुकम्मल हो जाती. So what you have with arbitration is not only privacy, not only efficiency, which allows for speed, but obviously with that comes the consideration that it becomes expensive. Parties are, as far as your client is concerned, he will not only have to pay your fees, but he will also have to share the fees of the arbitrator. So that becomes an issue. Lastly, I would say the main advantage when people think about arbitration is the finality of the process. The Arbitration Act of 1940 says it's one of the implied conditions that the award of the arbitrator will be final and binding between the parties. That's what the law says. But the difficulty that we have is, as I alluded to earlier, is that in an arbitration process, the award of the arbitrator under Pakistan law does not become enforceable until it becomes rule of court. In order to become rule of court, that award that you have gone through an arbitration process, you will have to file in the High Court, that will be numbered as a suit, and then in a way re-adjudicated before first a learned single judge, then there will be an appeal to a division bench, and then finally to the Supreme Court. Now, all of this, you may say, what is the use if we have already opted for an adjudication process, which was a private adjudication process, by which we decided that we will have a decision making by an arbitrator and not by a judge. Now you are telling us, as far as the client is concerned, that after spending time and money on lawyer and arbitrators, I will have to go back to court and again get a stamp of approval from the High Court, making the award rule of court before it becomes enforceable. Now, the real, perhaps, again, the word that I would have no choice but to use, the failure of arbitration process in Pakistan, and the reason we are falling behind is that we have failed to update our arbitration laws. All over the world, arbitration laws have been updated based on conventions that countries have entered upon, or even the United Nations have come up with model laws, the UNCITRAL model law I'm referring to. So, why does arbitration suffer just because it has to come to court? It suffers because of how we deal with awards in court. Because when an award comes to the High Court, and in this respect there's a judgment which I think has really put together all judgments on arbitration very efficiently together, is the judgment in the Jerry's versus Aeroflot case, which is 2018 SCMR 662. अगर आपने कोई एक जजमेंट पढ़नी है आर्बिट्रेशन पे, सिर्फ एक, तो ये जजमेंट ज़रूर पढ़ें. This is a Supreme Court judgment which really puts together all the laws of all the previous precedents on judgments on arbitration together, and seeks to answer questions in relation to what the court should do when an award comes before it. This judgment says it lays down as many as 26 principles of law. If you are in support of the award, if the award is in favor of your client, then you will cite this judgment for sure. Because, and I'll read a couple of sentences from this judgment. The Supreme Court says, court could not review the award or entertain any question whether the arbitrator decided properly or not on a point of law. That the court cannot intervene. It says, it is not open for the court to examine, re-examine and reappraise the evidence considered by the arbitrator, or it is not open for the court to hold that the conclusion of the arbitrator was wrong. So it is effectively shutting the door of the court when it is looking at an arbitration award. It says, when two interpretations are possible, the court could not interfere with the award by adopting its own interpretation. अगर दो interpretation possible है, arbitrator ने एक interpretation adopt की है, तो court के पास ये हक नहीं है कि वो कहे कि भाई ये जो interpretation, दो interpretation ज़रूर possible है, जो arbitrator की interpretation थी वो गलत है और इसलिए मैं arbitrator के award को set aside करता हूँ. तो Supreme Court कहती है ये आप नहीं कर सकते. Supreme Court ये भी कहती है that the court, when dealing with an arbitration award, does not sit in appeal and should not try to find out latent errors on the award. This is the Supreme Court laying down the law that when parties have opted to go for arbitration, have an arbitrator of their choice. That arbitrator, after hearing the parties, has decided a question, has adjudicated upon the matter and come up with that award should not be easily interfered with by the court when it comes to court for being made rule of court. The difficulty is that you can use the same judgment if the award was against you. Some of the other principles that this same judgment lays down is that the Honorable Supreme Court and the same judgment says that the court can set aside the award if there was any error, factual or legal, which floated on the surface of the award. Just in the previous sentence, it said that the court should not search for errors in the award to set it aside. Yet, the court says, even in the absence of objections, यानी कि अगर award फाइल होता है कोर्ट में, उसके खिलाफ कोई objections फाइल नहीं किए हैं losing party ने, कोर्ट कह रही है even in the absence of objections, award may be set aside and not made rule of court if it was a nullity or illegal. Now, we all know that on what grounds an award can be attacked, right? वो section 30 में legal misconduct का reference है और legal misconduct के ऊपर बहुत case law है कि at when do courts interfere with an award? And please understand why arbitration law practice in Pakistan is still at a very nascent stage is that our legal, our sort of interpretation of the Arbitration Act has allowed courts to interfere with a decision of the arbitrator which was considered final and binding, and that is still in very broad terms. It allows all the precedents, if you are, whether you are supporting or opposing an award, you will find enough material from the superior court's decisions to argue on why an award should be set aside or why an award should be enforced. But I should put a caveat in that more and more what we have is a tendency of non-interference in arbitration awards. And that tendency of non-interference in arbitration awards by our courts is which will allow our arbitration practice to succeed. And why do I say this? Is that if you see when you have any contract, when there's a contract entered into between a Pakistani company and a foreign company, they may agree to the award to be decided by a Pakistani arbitrator. They may agree for a contract to be decided in accordance with Pakistan law. But they will prefer that the venue of the arbitration be held abroad. The reason for that is, and this is where I now come to international arbitrations, which is again a subspecies of arbitration where you get more specialists involved, is in international arbitration, the most important thing for any person who's involved in any dispute, कि सर अगर मेरा फैसला हो जाए ना, तो that should not just be a paper decision, it should be enforceable. And what you see with international arbitration